Good afternoon. I hope you're enjoying this fabulous symposium, and many thanks to the symposium organizers and also to Caitlin Levesque and the entire board of editors of the Indiana Law Journal. It's my privilege right now to welcome you to the annual Harris Lecture at Indiana University's Bloomington's Maurer School of Law. This is one of our most important endowed lecture events, and we're honored this year to welcome a wonderful scholar and speaker. The Harris Lecture series was established in 1946, and it is our oldest endowed lecture. The series is named after Addison C. Harris, who was born in 1840 and lived until 1916. Addison Harris was a distinguished Indiana lawyer and statesman, a member of the state Senate and a minister to Austria-Hungary. He grew up in Indiana, and was one of the state's most well-known lawyers. After his diplomatic post, he returned to Indiana, serving as the president to the University of Indianapolis, a founder and president to the Indiana Bar Association, a founder and president to the Indianapolis Bar Association, and president of Purdue University's Board of Trustees. The formal launch of the Addison Harris Lecture Series began in 1958 with the dedication address of Chief Justice Earl Warren, who dedicated the opening at the time the new law building was dedicated. Past Harris lecturers have included some of the most prominent and distinguished scholars and legal minds of our generation. They are people who have changed the way we think and have had a tremendous impact on law and legal institutions. Over the decades, they've included some of the most well-known legal thinkers. Most recent speakers have included, among others, Judith Resnick, Mario Matsuda, Martha Minow, Reva Segal, Elizabeth Warren, Cass Sunstein, Julian Bond, Doug Kaiser, Jack Bolton. Last year, we were fortunate to have Adam Bodnar, the Commissioner for Human Rights of the Republic of Poland. Their remarks have all been published in the Indiana Law Journal. Today, I'm pleased that we're adding to this long list of distinguished speakers, and I'll now turn it over to Professor Steve Sanders, who will introduce this year's distinguished guest. Professor Sanders.
Thanks, Austin. Before I introduce Professor Post, let me just add, he has agreed to leave some time at the end of his talk for questions, and so if those who are in attendance would like to submit a question, please use the Q&A function through Zoom. And also, if you want to get a sense of what's coming up in the rest of the symposium with this afternoon's panels, the website is law.indiana.edu/compelled-speech. Robert C. Post is one of the preeminent legal scholars and legal historians of our time. He's the Sterling Professor of Law and former Dean of Yale Law School. And fittingly for this symposium, he's especially known and celebrated for his influential scholarship on the First Amendment. Professor Post's books and articles have ranged across a broad variety of topics, including campaign finance reform, academic freedom, hate speech, privacy in the digital age, commercial speech, and religious freedom. And that only touches on his First Amendment scholarship. Professor Post is currently writing volume 10 of the Oliver Wendell Holmes devised History of the Supreme Court, which will cover the 1920s under Chief Justice William Howard Taft. Some of his other major writings, and those I've personally taught and benefited from in my own work, focus on issues of democratic constitutionalism and the relationship between law and politics, including his enduringly important 2003 foreword for the Harvard Law Review, Fashioning the Legal Constitution, Courts, Culture, Courts, and Law. Professor Post is a member of the American Law Institute and a fellow of both the American Philosophical Society and the American Academy of Arts and Sciences. The article on his lecture, based on his lecture today, National Institute of Family and Life Advocates and the Construction of Compelled Speech Doctrine, will be published in the next volume of the Indiana Law Journal. And so along with the other participants in today's symposium, as well as my colleagues on the faculty of the Maurer School of Law, please join me in welcoming Robert C. Post.
Thank you, Steve, for that lovely introduction. Thank you, Jean Parrish. Thank you also to Sasha and Carolyn for organizing this great symposium, and thank you to Indiana Law School for the honor of giving this tremendous lecture. Among those who you've named as distinguished previous lecturers include my wife, Reva Segal, so it's wonderful to be following in her footsteps. I'm going to be talking today about compelled speech, and I'm going to be building on that fabulous first panel, which we saw and from which we can all take away a number of lessons. The first is that compelled speech doctrine is bloated, it's incoherent. The court has become extremely aggressive in using it to strike down statutes. And I'm going to be, and we saw different counsels of how to deal with that in the first panel. One was the fact opinion distinction. A second was, well, I'm going to summarize Professor Hahn as a counsel of despair. You know, do whatever you're going to do, just be candid about it. A third from Sasha was proportionality. I'm going to be giving a slightly different recommendation. And it's one I realize is quite unusual in a conference on First Amendment scholarship. I'm going to be arguing that what the court ought to be doing is being explicit and understanding what First Amendment values, specifically First Amendment values, are at stake in compelled speech. And I'm going to be arguing that it should do that in a socially, contextually specific sort of way. So not a trans-substantive doctrine like proportionality, but rather a doctrine which is aware of the social landscape in which compelled speech cases arise, and which in my view are actually the single most important dimension in how they are actually settled. So if we're going to start with the beginning, we know that the doctrine now, the court rests its compelled speech doctrine on an equation. The equation is one that Carolyn articulated in her opening remarks quite concisely and clearly, which is that the right to speak and the right not to speak are symmetrical rights. They're equal to each other. And the first thing I want to say about that is that we know it's wrong. We know it's wrong because we all talked about the Zouderer case in the first panel. Zouderer was a lawyer who wanted to advertise in Ohio, and the Ohio bar put two conditions on him. One, he had to disclose certain facts, and the second is that he couldn't speak certain things in his advertisements because they were misleading. And as to the second, as to the censorship of speech, the court imposed the central Hudson test, which is a form of intermediate scrutiny. And as to the second, the compelled disclosure of what the court called purely factual and uncontroversial information, the court developed the Zouderer test, which, as you heard, is a second cousin to a rational basis test. What the court said is, in the context of commercial speech, you can compel the disclosure of these uncontroversial facts so long as it's reasonably related to an appropriate state purpose. And Zouderer, I want to say, is a foundational decision because it teaches us that the kind of constitutional scrutiny which the court will apply to compelled speech depends upon the constitutional values which are at issue in the particular compulsion. So in Zouderer itself, it was commercial speech. What are the constitutional values at issue in commercial speech? The court has been quite explicit. It's the informational function, to quote Central Hudson. So we protect commercial speech so that the audience can receive information. If you're compelling speech, if you're compelling uncontroversially true facts, you are adding to the constitutional value. You're not diminishing the constitutional value in that setting. And that's to be distinguished from other settings where there are other constitutional values at stake. So to understand how to think about compelled speech doctrine, one has to understand first what constitutional values are triggered in any particular state mandated disclosure. And that should have been clear from the very beginning of compelled speech doctrine. So if we look at the first case, which we've already talked a little bit about, West Virginia State School Board of Education versus Barnett, 1943, the state is requiring children to pledge allegiance to the flag. And the court is very clear that one of the points that's at issue is that the forced pledge compels students, in its words, to declare a belief. I'm pledging allegiance. I'm not just saying facts. I'm giving an affirmation of what I believe to be true. And Professor Schifrin, Shauna Schifrin, whose name has already come up in our discussion, has given a very convincing explanation of the kind of First Amendment values which are at stake in a case like Barnett. She calls this her thinker-centered approach to the First Amendment. And she says the First Amendment value that is compromised in a situation like that is that the state, and I'm quoting her now, objectionably interferes with the free development and operation of a person's mind. So in Barnett itself, because every day the students had to reiterate the Pledge of Allegiance, Schifrin says, requiring potentially insincere recitation, and especially rote and periodic recitation, poses constitutional problems because it utilizes disrespectful methods of communication and persuasion. These methods constitute efforts forcibly to inculcate and to instill rather than to persuade through direct, transparent arguments, reasons, etc. So she draws this distinction between education and inculcation and the manipulation and instrumentalization of the mind of a person. That's what she says is really wrong in Barnett. And to me, at least, that's persuasive. But now if we look at the second compelled speech cases, we have to jump ahead 34 years to 1977 in a case called Maynard Woodley versus Maynard. And in this case, we have a Jehovah's Witness who objects to having on his license plate in the car that he's driving in New Hampshire state motto, which is live free or die. And interestingly, Maynard, George Maynard, who's the plaintiff in that case, does not allege that he's being forced to declare an insincere belief. He's not saying I'm forced to pledge anything. He's not forced to say what's true and not true. Instead, he alleges, and I'm quoting, that he has been forced into advertising a slogan which I find morally, ethically, religiously, and politically abhorrent. That's a very different kind of claim. That raises very different kinds of constitutional values. The vices of iteration, of manipulation, of insincerity, which were identified by Shiffman and Barnett, are plainly not present in Woodley versus Maynard. It's plainly difficult for Maynard to argue that his independence of mind was undermined by the text printed in the back of his car on his license plate. Very hard to make that case. But the court nevertheless wants to claim Barnett as a precedent. So in what sense is Barnett a precedent for this when Barnett involved an entirely different set of constitutional values? And the answer is, and this is where we have the original sin of compelled speech doctrine, the answer, says Chief Justice Berger in Woodley, is that the right to speak and the right to refrain from speaking are complementary concepts. So here we have the origin of this equation of the right to speak and the right not to speak, and it's used precisely to obscure the fact that the court has not articulated the constitutional values which are actually at stake in Woodley versus Maynard. And to this day, it remains obscure what the constitutional rights are that the court is trying to protect in Woodley versus Maynard. If you look at the academic literature, it's all over the map about exactly what's being protected there. And so given this origin, it's of course no surprise that compelled speech doctrine has swollen into an engorged river of aggressive and incoherent holdings, which are spreading, as we saw in the first panel, all over the landscape, and which are being put to libertarian and ideologically inappropriate uses. So how are we going to think about this question? Well, what we need to, the way I frame this question is at all correct. The first question is, what are the constitutional values at stake in any given case? And the second question is, well, maybe cases are different. They aren't all alike. So we want to be kind of cautious. We want to think about in what cases are what constitutional values actually present and demanding a constitutional response. That's how I think a sane judge would respond to this situation, but that is not how our court has responded. It's responded with extreme abstraction and extreme overreaching and extreme aggression. And today I just want to talk in some detail about one of the cases that did that, which we've already talked about a lot in the first panel, NIFLA. And NIFLA involved the FACT Act in California, which you've already seen described. And what basically the FACT Act required is that CPCs, which are crisis pregnancy centers, CPCs are organizations that tend to be run by those who are committed to a pro-life position. They believe that abortion is morally wrong. They want to persuade women who are in the market for an abortion not to have an abortion. And California had some evidence that these CPCs were misleading women into thinking that they were, in fact, abortion providers. And so the women go there and they get caught in the toils of this persuasion. And in a context of abortion, time matters. If you wait too long, it becomes more dangerous to have an abortion. Sometimes you can't have it, etc. So California decides to respond by requiring these CPCs to put up a notice saying, and I'm being extremely simple because I don't have much time, so I'm going to talk at a very high level of generality. We can get into the details later, but California requires these CPCs to put up a notice with relevant information, like California will provide you at low cost reproductive health services, or this facility doesn't provide medical services. So that's the fact pattern at issue in NIFLA. And Justice Thomas, writing for a court of 5, it's a 5-4 opinion, holds that fact is invalid. Why? And this is the doctrinal move that he makes. He says that whenever you compel individuals to speak, and in particular speak a particular message, that's a content-based regulation. Why? Because it's forcing them to do a particular message. All content-based regulation is presumptively unconstitutional. It should normally have strict scrutiny, but at a minimum intermediate scrutiny, and in most events, it's not going to survive. That's the doctrinal holding of NIFLA, equating compelled speech and content-based regulation. Notice that's not a modest holding. It's extremely abstract, extremely far-reaching, extremely general. So where the hell does Justice Thomas get that holding from? He purports to be an originalist. This doesn't come from the original meaning of the First Amendment, obviously, because the First Amendment for the first century and a half of its existence applied only to prior restraints, not to subsequent punishment. So it's nothing to do with the 18th century 1791 First Amendment. This is obviously not coming from the text, which tells us nothing. So where is Thomas getting this? It's a puzzle. A better situation. So he actually raises the question for us, how should we know what the right answer to this question is? It's not easy to know. So I'm going to make a very modest suggestion, and not a Swiftian sense. I mean this as a modest suggestion, that we do what we teach every first semester law student to do. Think of situations. Think of whether, when you compel speech in that situation, it should be regarded as a content-based regulation subject to heightened constitutional scrutiny. Just think of different situations and then decide whether a rule like that makes sense. It's a very simple method, right? This isn't rocket science. So let's take one method that we've already talked about. Let's just take medical care, since we're dealing with NIFLA. So I'm going to propose to you this hypothetical. Sam injures his leg. He goes to the doctor. The doctor looks at it, says, "You're going to be fine, go home." Now, what the doctor should have said is, actually, this injury that you have has the potential to getting infected. So I want you to come back and we're going to be checking for infection. Doctor doesn't say what he should have said if he were to provide competent medical advice. He just says, go home. So Sam goes home, doesn't come back, his leg gets infected, it gets amputated. And here I'm just giving you the facts of a perfectly ordinary medical malpractice case out of Louisiana. Notice, I'm not doing anything fancy here. I'm just giving an ordinary case. And so Sam sues for malpractice and he wins. The doctor loses. It's a case called Malone. And the law here would have required the doctor to say a specific message. You should come back because this has the potential for being infected. And the doctor doesn't say it. Does the doctor have a First Amendment? Does the doctor have a First Amendment defense? I doubt if the doctor even has a First Amendment. He certainly doesn't have it in the run-of-the-mill malpractice suit. I'm living to learn from Nadia's paper subsequently, but I have very rarely seen, like I say, I've never seen in an ordinary malpractice case a First Amendment defense, even though malpractice comes from speech almost all the time. And it often comes from the failure to speak. And I would dare say, not only is this true, as a matter of fact, it's normatively attractive that it's true. I can't think of people who want to constitutionalize all of medical malpractice whenever it involves the failure to give needed advice. And if you think that's a problem with doctors, just think about lawyers. Lawyers just deal with their clients by talking to them, and lawyers are subject to malpractice. And it doesn't make any difference whether the lawyer says something wrong or fails to say something that should have been said. Either way, malpractice is a perfectly ordinary response to the failure to provide competent legal assistance, or think of accountants, etc. I would dare say most people would regard the constitutionalization of malpractice law in the way that NIFLA would prescribe, namely it's content-based regulation and therefore subject to elevated scrutiny, as a nightmare. And if you think there's something special about professional malpractice, consider another simple example. You're in a courtroom and Amy is testifying, Amy's a witness, and Amy's asked a question and she doesn't want to answer the question, but she doesn't have any good claim of privilege. So the judge orders Amy to answer the question, particular message, answer that question. And Amy says no. So the judge says, you're in civil contempt. Very common situation. You see this all the time. Is that judge to be subject to First Amendment scrutiny, heightened scrutiny for compelling a message because it's content-based discrimination? Let me just say, if courts couldn't compel lawyers or witnesses or parties to talk all the time, you could barely run a courtroom. So do we want to have this NIFLA rule there? No. And I've just given you two simple examples, but I just want to say it's child play to think of dozens of other examples just like this. So the president, I wrote this, Trump was president. So the president fires the Secretary of State for not saying what he wants him to say. Is that going to be subject to content-based review because elevated scrutiny? I don't think so. Or you're a professor at Indiana State University and you penalize a student for not turning in an assignment or for not answering the question, whatever. Is that going to be subject to elevated scrutiny because it's content-based regulation? Or, it's about to be April. You're about to file your income taxes. You're compelled to answer specific questions in your income tax. Elevated scrutiny because it's content-based regulation. Or, a simple example like the Truth in Lending Act. You want to lend someone money, you have to give certain disclosures. Heightened scrutiny? No, of course not. So, anyone in this room could think about many, many, many examples where there's compelled speech. It's content-based under the test of NIFLA, and yet not only should heightened scrutiny not be involved, it's a question whether we even have a First Amendment case at all, unless we want to constitutionalize broad swaths of our law, which we do not constitutionalize. Now, why is this true? It has to be true, and I'm reading backwards now, I'm reverse engineering, but it must be true because the constitutional values that are triggered by compelled speech doctrine. When we care about compelled speech doctrine, we do because there are constitutional values which are brought into play. Those values are not in play in these other examples. So what does that mean? What does that mean? That means that these constitutional values are sometimes present and sometimes not present. And you can't just say from the fact that there's compelled speech that the same constitutional values are always there. Now, what are the constitutional values that are present in compelled speech? And modern legal scholarship has I would say, come to the fore and has given us wonderful work explaining the many different kinds of constitutional values which can be at stake in a compelled speech. Many of the people who I'm looking at on my screen have written terrific articles on this very point. And these values range from the autonomy of the speaker to the autonomy of the audience, to the distortion of the marketplace of ideas, to preventing unwanted connection with the views of another, 15, 16 of these values that we can all put on the table. This is all different kinds of values. And to think that they can all be captured by this notion of content discrimination is kind of crazy to begin with. So we wouldn't, if it is true that these different values are present in different contexts, then we wouldn't want to think about the situation in the abstract, categorical, mechanical way that Thomas writes NIFLA. So when are these values present and when are they not present? How do we know the answer to that question? And I'm going to suggest we use exactly the same method that we just used to think about content discrimination. Think about concrete situations. And you say, what values are present in these situations or not present? So let's just take one example, since I've already talked about it a little bit, the value that Thomas Schifrin has put forward, the thinker's First Amendment, the independence of mind and the autonomy of the person, of the believer, of the thinker, not merely of the speaker, which she used to give a very, I think, convincing account of what's at stake in Barnett. How present is that value in other examples? So let's take our medical malpractice example. You might know of the example of Stella Emanuel, for example. She's a Texas, of course, it has to be from Texas, a Texas MD, a doctor who firmly believes and has written that hydroxychloroquine cures COVID, right? This is her personal belief. And she's committed to this. She's passionately committed to this. She's got, whatever it is they do over YouTube, many of them talking about the value of this drug. So she prescribes a drug to a patient. The patient is harmed. The patient sues for malpractice. Does Dr. Emanuel have a First Amendment defense because she happens personally to believe in hydroxychloroquine? I don't think so, right? We don't care what she personally believes. It has absolutely irrelevant to whether she is liable under medical malpractice law. It's an irrelevance. The only thing medical malpractice law cares about is that she provide competent medical advice. And in fact, what happens under medical malpractice laws, the law defines the role of the physician. It defines it instrumentally to provide for the patient competence, medical competence. And the patient is is concomitantly entitled to competent medical advice. And what's irrelevant to this question is whether the personal autonomy of the physician is impaired. What's irrelevant is whether her independence as a thinker is impaired. What's irrelevant is whether she's being instrumentalized. What's irrelevant is all the values that Shauna Schifrin puts on the table for Barnett, right? And why is that? Because the law has constructed a different kind of social relationship, and only certain values are relevant to that relationship. And we all buy into that because we all have to go to the doctor and we want competent medical advice. And we don't want the doctor looking at you after they've said something incompetent and saying, well, you know, what I said, it's an experiment, like all life is an experiment. So you can't hold me competent. You can't hold me accountable. Or there's a marketplace of ideas here, lump it. We don't want our doctors saying that to us. We want our doctors giving us medical advice. And because we believe in that, then we say these other First Amendment values are not present in that social relationship. And this is what this is telling us is that in our social life and through the law, we create lots of different social relationships as to which some forms of social accountability are relevant and other forms are not relevant. Some constitutional values are relevant and other forms of constitutional values are not relevant. So what I've just suggested would go for any professional law. It would go for your lawyer, for example. If your lawyer were to say, you know, I personally believe that taxes are unconstitutional, so you don't have to file your taxes. I don't care what you believe. You know, what I want is competent legal advice from my lawyer. And that's true for all of professional advice, but it's even true for a broader swath of our life. It's true for what I have another word called managerial domains. What are managerial domains? When the state wants to accomplish a purpose, it creates an organization. When you're in the organization, the state deploys and arranges its resources, including its people, including the speech of the people, in order to accomplish the mission of the organization. And the constitutional law knows this perfectly well. So take a perfectly standard government bureaucracy like the Social Security Administration. If you're an employee of the Social Security Administration, you can't give clients your personal view of how Social Security works. That's not how you have to give the official policies of the organization, right? And, you know, the case that you want to think about here is Garcetti, which says, you know, when you're acting qua employee, your autonomy is quite irrelevant. All these constitutional values are irrelevant. The only thing that's relevant is the instrumental use of your voice to accomplish the legitimate ends of the organization. And that's just the way we work within organizations. So let's take the example we gave before about Amy testifying. A courtroom is a perfect example of a managerial organization. And that means speech is arranged within the courtroom and regulated within the courtroom to accomplish the mission of the court. That mission is the attainment of justice. And we have lots of rules which tell us when you are attaining justice and when you're not, when a witness has to speak, when they don't. And the question for regulating speech in the courtroom is the rule justifiable for the mission of the court? And if it is, then the court gets to tell the witness to speak. And if it isn't, then the court made a legal mistake, but not a First Amendment mistake, made a legal mistake in determining what was necessary for justice. Now we have disputes about the boundary of the courtroom. The lawyer can be compelled to talk or not talk in the courtroom. The lawyer walks outside the courtroom, gives a press conference. Which First Amendment rules govern there? Rules of the court, the managerial domain, or the rules of, say, ordinary public opinion formation? This is a controversial question, and many of hot button issues are about the boundaries of these organizational domains. But when you're in the organizational domain, it's not really a hard question. Now, if we come back to Barnett, we see a really interesting phenomenon. Barnett is about a managerial organization. It's about a school. And in school, we regulate speech constantly in order to attain the mission of the school, which is to educate our students. So if I'm in a classroom, my students don't get to talk as they want to talk, and they must talk if I'm calling on them, right? We don't make the distinction between compelled speech and censorship of speech. We arrange speech instrumentally to attain the ends of education, and that's how my conduct in the classroom, whether I'm in a state school or a private school, is judged. So what it actually is going on in Barnett, since Barnett seems to have this idea of autonomy in the school, well, it must be the case that Barnett has a picture of education as to which the Pledge of Allegiance is inconsistent. And what would make it inconsistent? So what's fascinating about Barnett is that Schifrin points to a lot of elements of compulsion in Barnett, which are actually quite routine in schools. He says, you're forcing someone to recite in an iterative fashion. You're forcing someone to memorize. You're instrumentalizing. But schools do that all the time. They force students to memorize and recite the multiplication tables. They force them to memorize and recite the alphabet, right? Is that a bad thing? They force them to recite the Gettysburg Address and to memorize it. I remember having to do that in school. Is that a bad thing? Is that violate Barnett? So I think plainly not. We want our schools to teach the students alphabet and multiplication tables and maybe even to memorize the Gettysburg Address. So how does Schifrin, who's really smart, deal with this? She says, well, there's a difference, she says, between, I'm quoting her now, compulsory education and compulsory inculcation. This is how she distinguishes it. So, of course, this raises the obvious question, how do you know one from the other? And I think the way you know one from the other, says Schifrin, is, well, if you're undergoing compulsory education, you're being forced to do things which actually increase your independence of mind. So if you know the multiplication tables, it increases your independence of mind because you can do more arithmetic than if you didn't know the multiplication. The same for the alphabet. And a forced inculcation shuts down your independence of mind. That's the Pledge of Allegiance. So, all right, that's fine. How do I know the difference between those two things? I'm going to suggest to you that's not a constitutional difference. That's a difference in your theory of education. You have a theory of education that tells the educator, tells me when I'm educating the class, when am I improperly inculcating a student and when am I educating a student? And this is controversial over the domain of education, which is over the domain of what you're doing in a school. Now, there are constitutional decisions which valorize independence of mind as the purpose of state education. Tinker is a perfect example. Tinker says you can't imagine students merely as the closed circuit recipients of what the state chooses to communicate, right? And the purpose of education is therefore to produce in the students a mature independence of mind that will allow them to become democratic citizens. And that would be compatible with what Schifrin is unpacking Barnett to say and what Barnett itself is saying. I should also say there are other Supreme Court decisions which have a different theory of the mission of education. Think of a case called Frazier. Frazier says this: the role and purpose of the American public school system were well described by two historians who stated, quote, public education must prepare pupils for citizenship in the Republic. It must, look at the verb here, it must inculcate the habits and manners of civility as values in themselves, conducive to happiness, and is indispensable to the practice of self-government in the community and the nation. I mean, speaking roughly, there are Supreme Court decisions that say the purpose of education is Durkheimian. You have to socialize students in common norms. And there are others which are Piagetian, which say basically you have to make students think for themselves and become independent, autonomous. This is a debate within American constitutional law of what the purpose is. So Barnett is plainly a decision in the tradition of Tinker, before Tinker, Tinker's in the tradition of Barnett. And basically what it's saying is the purpose of education must be to preserve the independence of future democratic citizens. And that's what's underlying this incredibly soaring rhetoric in Barnett, which is always cited. For example, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act of faith therein. Now, that rhetoric is unforgettable, but it's also extremely questionable. What do we mean when we say there's no orthodoxy and you can't force students to have an orthodoxy? What are we doing when we force the understanding of the multiplication tables? Okay, you say that's facts, it's not opinion. So what are we doing when we're forcing students to memorize the Gettysburg Address? Or any poem that you had to memorize when you were in English class in 6th grade. These traumatic experiences of having to, repeat Matthew Arnold or whatever. That is certainly forcing us to memorize matters of opinion. So what is Barnett resting on? That it must rest on the difference between pledging allegiance to Matthew Arnold and reciting Matthew Arnold. To recite the Gettysburg Address is not to say it's correct. the way it is, you are saying, I pledge allegiance to the flag. That's a different confession of belief. So that's a perfectly sound distinction, but notice how narrow Barnett is once we make that move. That's about forced confessions of belief, not indoctrination. And that's a wholly different kind of issue. More importantly, you know, when Barnett makes this claim about what we are as a republic, it's a plainly false claim. When Barnett says there's no orthodoxy as to matters of opinion, tell that to all the hundreds of lawyers who are liable for malpractice for writing false opinion letters. And there are many, because I did some research on this before giving this speech. You know, you give an opinion letter, say you can acquire this property, it turns out to be a bad opinion letter, you are liable, and you can't say there's no orthodoxy in matters of opinion. So this generalization of the claim over the whole social field is plainly wrong. And that's telling us that the kinds of values that Barnett is protecting are relevant in some social situations, but not in other social situations. And why is that? Because we live in a world, as Durkheim taught us, of division of labor. We live in a world in which we occupy numerous different social roles. And these roles are all organized according to different logics. And these logics will intersect with constitutional values in completely different sorts of ways. And whenever we attempt to abstract a constitutional doctrine like no orthodoxy in matters of opinion, we are flattening the highly differentiated social landscape that we actually inhabit. And it turns out, when you look at how constitutional law works, these different logics of these different social roles tend to domesticate abstract constitutional values. They tend to take these values and chew them up and subordinate them. And it's for that reason that no one, I take it, no one would think twice if the president fires a secretary of state for refusing to say certain things that the president wanted him to say, because everyone understands the social role of the secretary of state and how that subordinates any abstract statement of constitutional values. Now, why do we find Barnett such an important opinion? Because it tends to articulate values which, in my view, and this would be a discussion that arises out of the first panel, in my view, tend to underwrite normal, or what you would all call ordinary First Amendment doctrine. That doctrine protects our ability to participate in the formation of public opinion, which I'm going to call public discourse, those speech acts which we deem necessary to participate in public opinion. Why do we protect that? We protect that, in my view, because of the importance of democracy. And what's the connection? Democracy is, as Carl Schmitt wrote in one of the few true things he wrote, democracy is government by public opinion. And if we're free to participate in the formation of public opinion, and if the state is responsive to public opinion, then I can imagine that the state is responsive to me. And so the First Amendment protects this essential value of democratic legitimation, which is my belief that I live in a state that is democratically responsive to its citizenry, including me, including the people who can participate in the formation of public opinion. And if you look at the Supreme Court opinions, they will articulate this, even in a case like Citizens United, as speech being an essential mechanism of democracy and as protecting the ability to live in a democracy. That's the connection between the First Amendment and this isn't, speaking about political matters, it's participating in the formation of public opinion, which is a totally different understanding. So Barnett treats students like future participants in public opinion, and it brings the same value of autonomy, which the court uses to develop its public discourse, to the school. And that's why Barnett has become such an influential decision outside of a school. And the essential point here is, as Barnett said in 1943, it says, authority here meaning the United States, in the democracy of the United States, Barnett says, authority here is to be controlled by public opinion, not public opinion by authority. That's the essential constitutional value that Barnett puts on the table. And if you have that value, then I want to say that compulsory speech is in fact problematic, because the state cannot and should not be able to compel speech, even the kind of pure facts, in my view, that Alan was talking about earlier in the first panel, within public discourse, because the government would then be manufacturing the very public opinion to which it's supposed to be responsive. It contradicts the reason why the government has hands-off public discourse in the first place. Compelled public discourse contradicts the foundational value of democratic legitimation also because it alienates persons from the very speech that is meant to underwrite their experience of self-government. Now, that suggests that a rule articulated by NIFLA might have place within public discourse, but it doesn't suggest it's a general rule to look at compelled speech qua compelled speech. It means compelled speech within a certain social setting in which this constitutional value of democratic legitimation is paramount. And that's all it's saying. And that's also going to be suggesting that there are a lot of other social situations where this constitutional value is not paramount, in fact, not even present. And that's, of course, what we saw by our many examples of speech within organizational domains or speech within professional roles, etc. In most situations, compelled speech is going to take on the flavor of the constitutional values which are relevant in the particular social setting and the particular set of social roles. And that has a very important implication, I think, for modern compelled speech scholarship. Modern compelled speech scholarship takes the object of its analysis to be compelled speech in the abstract. Compelled speech qua compelled speech. And what I want to suggest to you is that may be looking at it through the wrong end of the First Amendment telescope. The right end of the First Amendment telescope might be looking at the values which might be present, but only present in particular social settings. Now, these social settings don't exist in nature. They're constructed by courts as much as anything else. So take a simple example. You have the military soldier in his barracks in the army, and he's writing to his local newspaper reporter, who's a friend, my commanding officer is a jerk, right? And the question, and he's going to be disciplined by the military. Is he now a soldier who is being mutinous and disobeying military discipline, i.e. within the managerial domain of the military, or is he a citizen complaining about a public official, his commanding officer? We could characterize in the abstract that speech act in any way we want. As we choose to characterize it, so we will create the boundaries of the managerial institution of the army. And so we will also, by in a complementary way, create the boundaries of public discourse. And court could go either way, but these are the stakes in how it decides that question. Now, let's come back to NIFLA with that, because the insight that we just came to is that many of the most difficult issues of First Amendment doctrine are decided in the first instance by the normative characterization of the social world, in the way that we talked about the court deciding the normative characterization of the private's letter to the newspaper reporter. What about NIFLA? Notice we could say there's many different normative characterizations of what's going on in NIFLA. We could describe what's going on there as the speech of the state of California. We could describe it as forced public discourse by the CPCs. We could describe it as a commercial disclosure by a provider of public health services. And notice that completely different doctrine would apply depending on how we describe that. If it's the government speaking, then there's no First Amendment restraints on it at all. If it's the forced public discourse of the CPC, it should be unconstitutional. If it's just an ordinary commercial disclosure out of Zouderer, then it's under the Zouderer rule. It's probably okay. And notice that as I characterize what's going on with this Speech Act, I've given you different doctrines you can trigger into, I get completely different results. And let me just say that if the court had spent some time telling us how it was going to characterize the Speech Act as a matter of the normative characterization of the social landscape with which it was dealing, it would have been much more convincing in its opinion than any of the doctrinal moves, which are abstract and kind of wooden, that it actually makes. Now, I want to say, speaking for myself, and this is just me talking, I don't regard this as compelled speech by the CPC. These are notices with the state of California on them. It's plain to anybody. It's the state of California talking. It's not the CPC. But nevertheless, the CPC could have regarded this as a compelled factual disclosure, which undermined its own public discourse. Because here I am trying to convince these people that abortion is a bad thing, and the state is getting in the way by these compelled factual disclosures. And, it's a question I put to Alan in the first panel. Suppose that the state says to Trump, you have to tell the truth when you're talking about the election. Trump would regard that as getting in the way of his public discourse. So you could see that. And then the question is, if it's really the public discourse of the CPC, the state is getting in the way. On the other hand, I could characterize that as a commercial disclosure to those who are seeking public health services, in which case it's a public disclosure like the many public disclosures, which we heard about in the first panel, which are required in the commercial sphere. Which is it? The CPCs regarded this as their public discourse. The women, no doubt, regarded it as a disclosure that they expected from the state when they were getting publicly available commercial services. And they want the state to assure them that they're not being misled. So which point of view should the court adopt? The court plainly adopted the view of the CPCs and not of the women. And what justifies that? Well, the first point here is that the court's whole doctrine depends upon an anterior normative characterization of the social landscape. That is the CPC's view, which should govern what this is. And that's crucial to the court's finding. And that's already telling you something about what I was mentioning before in the lesson for contemporary scholarship about compelled speech. Because if the same act can be characterized in so many different ways, depending on whose perspective we're taking, that's telling us that compelled speech is not the natural category. That the natural category is instead, what is the normative nature of this social relationship that NIFLA is deciding? And that means an understanding of distinct social practices and an understanding of the methodology we have for deciding among these practices. And the perception and valorization of these practices, in fact, correspond to the experiences we have of distinct social roles and institutions. Now, I suspect that this is what Oliver Wendell Holmes had in mind when he said so long ago that the life of the law is not logic, like compelled speech. It's instead experience, like these social roles. This well-worn aphorism, I think, might do well to inform our contemporary compelled speech jurisprudence. Thank you.
Professor Post, thank you on behalf of the symposium, on behalf of the Maurer School of Law. Those who are attending, and we're really happy to have almost 150 people from near and far in the audience participating in this program. If you have a question for Professor Post, we don't have a microphone for you, but the Q&A function in Zoom is available. I'm not seeing anything yet, so I would invite any of the participants in the symposium itself, if you have something for Professor Post, to just go ahead. And I think as long as everyone doesn't talk at the same time, you can just unmute and ask your question, or if everybody starts talking at once, we can use the raise hand function. We have, about 15 minutes or so. So,
Robert, just a real quick question. Can you tell us about how in identifying the specific social role and expectations the court can maintain a level of legal objectivity that you're seeking, as opposed to moving in a more ideological direction?
I think that's what courts do all the time. I mean, I think, you give me a First Amendment case and I can show you how inside the case and prior to its articulation, or sometimes even as a matter of its articulation, that's what it's doing. I think 80% of interesting First Amendment cases turn on precisely this. And that's what judges do. They are interpreters of our own social norms and our own social practices. And when we think about the law as abstracted from that, that's when we get into trouble.
All right, we have a question from an audience member. Could a state, as part of granting health or business libraries, give them the option of displaying a state-provided rainbow sticker if they provide wedding cakes to gay and lesbian clients? I think that's supposed to say business licenses. Could a state, as part of
I'm losing the question here. Could you just repeat it?
Sure. Could a state, as part of granting health or business licenses, give the business the option of displaying a state-provided rainbow sticker if they provide wedding cakes to gay and lesbian clients?
I don't know why not. I mean, what would be the issue here if it's optional and if it's available?
I guess
what would be the claim?
Is that it comes from the sticker comes from the state itself, and maybe I'm just channeling the.
I get a sticker when
state endorsement.
I get a sticker when I vote. It says I voted. Now, is that going to be a problem? I'm kind of proud of that sticker myself, but I don't have to wear it.
All right, until we get any other audience questions, other participants in the symposium.
Robert, I was wondering if you could address the importance of keeping the examples that you cited, like malpractice, outside the scope of coverage rather than dealing with it through coverage. Because it seems to me that, a malpractice claim, you have to already prove harm, which, should pass even like the sort of Alvarez test, the sort of, leading theories of where the doctrine seems to be going. And you have to prove causation too. And so it does a lot to kind of pass scrutiny, even if we apply it. So,
right. So that's a good question. So think about an example like this. Texas, I think, requires doctors to tell women who want abortions that abortions cause breast cancer. That statement turns out to be false. Should the doctor have a First Amendment claim? If your point about coverage not extending to the doctor-patient relationship were to be true, then the doctor would have no First Amendment claim. I think the doctor should have a First Amendment claim. And I think the difference here is malpractice actually corresponds to what the First Amendment value is in the doctor-patient relationship, which is the communication of accurate information. And malpractice law is generally structured among all the states to guarantee the disclosure and communication of accurate information. But the state can nevertheless organize the professional relationship to give false information, like I just gave you, or ideological information. South Dakota comes very close to saying that a doctor has to tell his patient, her patient who wants an abortion, that the fetus has a soul. And I don't think the South Dakota should be able to do that either. So I think that the doctor should have, it's a jus tertiary point, but just like an abortion point, raise the claim of the patient that they are being force-fed by the state, inaccurate, incompetent information, and the doctor should have that under the sign of the First Amendment. So I don't want to go all the way to the notion that it's not. And you'd have to tell me exactly why it's not for other reasons. You could say conduct, but obviously it's not conduct in any ordinary language sense of the term. So in what sense would it be beyond? It's very interesting now, the trend, the libertarian trend. You see it in the on-bank decision in Florida, Wolfshanger, and you see it in King in New Jersey. The courts of appeal are saying, well, speech by the doctor speech. It's like, really? But that's where we're going in the opposite direction, actually.
That's actually the direction that I was pushing from, is why not just push in the opposite direction and allow coverage to work out which claims survive.
Well, you'd have to ask yourself, what are the values at stake? And my own view is that the values at stake are very much like the values we see in commercial speech. And therefore it's not nothing, but it's not the kind of thing where speech is speech.
We have, I think this may be more of a provocative comment than a question, but it comes from Tim Riffle, who is partner at Barnes and Thornburg, teaches as an adjunct here at the law school. He says the kind of state-compelled speech the First Amendment should protect the speaker from having to utter is compelled speech to undermine First Amendment protected speech the state cannot prohibit the speaker from uttering. I'm not sure if Professor Post has a reaction to that or not, but that's Tim's contribution.
Well, I don't know. I'm not sure exactly. I mean, it's a very broad statement, an abstract statement, and I'm not good at thinking these abstractions. But take tax returns. Does that fit under the principle that you just said? I'm being forced to give my things, but is it because I'm protected in giving my income to the general public that I'm? What is going on there? And it seems to me I can think of a lot of situations where that statement wouldn't be true, but I'd have to sit down and think about it very hard because you're talking about a lot of different things at the same time.
And it's funny, Tim Riffle is a tax lawyer and teaches tax law.
Oh, so there you go.
All right, our colleague Joe Tomaine asks, what are your thoughts on the Americans for Prosperity case currently pending before the court? Is this like NAACP versus Alabama, or are the values at stake different?
Remind me of what's at stake in that case. What are the facts of that case?
I'm going to just let Joe Tomaine speak. Joe, I'm going to unmute you if you want to say something. I think I'm able to do that. That might be the fastest way. So Joe, go ahead.
Yes, thank you. Thank you for the lecture. This is wonderful. This is the case about the disclosure requirement for nonprofit organizations.
Disclosure requirement for what? I didn't hear. Nonprofit
Organizations like Americans for Prosperity.
And so this is the issue of dark money in campaign finance. Is it disclosure in campaigns specifically we're talking about?
Yes, thank you.
Yeah. So, I mean, here we have a very particular problem, which is how do I conceive elections and election speech? So notice most countries in the world do not consider election speech different than political speech. And why is that? Because elections are organizations designed for a particular purpose, and therefore you can arrange how people talk within the elections differently than for general public discourse. So, and we have traces of that in our law. There are disclosures which are required for election speech, which are different than disclosures that would be required generally. We have certain rules that apply to election speech, which we don't apply to speech generally, but on the whole, our court has been very hostile to this distinction between elections and public discourse. And the question of how to analyze that is whether the court is willing to go along this line that elections are just political speech by another means. And the danger of going down that line is that elections lose their constitutional purpose. The point of an election is to legitimate democratically elected officials, give our elected representatives the confidence of the general public that they have been elected by the general public. And if our elections don't accomplish that purpose, then we are in trouble as a democracy. And that's the difficulty which the court is not dealing with in its election campaign finance decisions. And I think the court is going to have to begin to become more sophisticated in how it deals with it. But that's not to give a specific answer to a specific case. I need to see a lot more to do that.
My colleagues Susan Williams and Dan Conkle have their hands up. And so I'll ask them to go in turn and just unmute and ask their questions. Susan and then Dan. We're about 3 minutes from 1, but I think we can go a little bit past 1 if we keep the questions and answers efficient. So Susan, please.
Thank you. Robert, thank you for this wonderful, wonderful lecture. I love the idea that we're going to go starting with the values at stake. And of course, I have tremendous sympathy for your vision of social context being the crucial thing for determining which values are at play in a given instance. What I'm struggling with is the fact that so many social contexts actually seem to combine elements of different domains. So many of the places that we might describe as managerial domains, they intersect, right, with the domains of public discourse or with other domains like, a medical setting or something where we really think of it as provision of public services, or, there are intersecting circles here. And so I'm really interested to hear more about how we're supposed to tell which set, if they're an intersection, do all the values come in, or do we have to make a choice?
Should I respond now, Steve, or am I going to wait for Dan?
No, I think you can go ahead and then Dan.
Okay. So
I would suggest, if I could just jump in for a second, because I was actually going to ask a very similar question. So I might build on Susan's and you can respond about the terrific lecture, by the way. But in the specific context of NIFLA, you suggest that on the one hand, it might be the state providing information, disclosure in a medical context. On the other hand, it might be state interference with the organization's political message. And I guess my question is, isn't it both? So I think I'm following up to some extent on what Susan said. So maybe you can respond to both.
Yeah, I mean, I think the way we have to think about law is a structural system that is guilty, not guilty, on, off, you know. And in the end, what the role is of judges is to say, what is the predominant way to characterize this social relationship? So yes, the world is actually complicated, and in the real world, there's all these overlapping systems. So let's take a town meeting, for example. Meiklejohn says that's the essence of democratic self-government, but actually it's not at all, because somebody is setting the agenda, somebody's telling you when you can and can't talk, you have to speak in turn, you can't speak in a duplicative way, you can't speak out of order, blah, 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 right? So there's 10,000 rules that apply in a town meeting that don't apply to public discourse, even though both are about democracy in some sense, right? And that's because the town meeting is organized to reach a decision, and public discourse is precisely not organized to reach a decision. And that, in the end, that's what judges are for. They're to say, look, in the school, it's really about this. And when they conflict, this is the value that's predominant. And I think that's the way judicial decisions are written. That's what we ask courts to do. And so in the real world, nothing corresponds to this kind of idealized image that I'm giving to you. But in law, they actually do. It actually tells you, you know, which is the predominant constitutional paradigm that's going to apply here or there or someplace else. And as I suggested with my simple example of the soldier in the barracks, this is performative by courts. It's not that they discover the right answer, because there isn't a right answer. They make the right answer, but they make the right answer in a way that is dialectically connected to the rest of us. If we don't like their answer, we can change what the law is. And we do commonly, you know. And so courts are always putting in a bid for our understanding and legitimation. And then we're always evaluating that. Paul Bohannon, the legal anthropologist, said, law is the double institutionalization of norms. You know, it takes norms from outside itself, it reinstitutionalizes them within the legal system, and then the society takes those and modifies. This is how you have to understand this: in motion, in time. And that's what constitutional law is to me, you know, this constant dialectic back and forward. But what it isn't is abstract philosophical questions about autonomy in the abstract, because we don't live in a world like that, unfortunately. Great if we live behind the veil, but we don't. And this is what the courts are telling us. And then we modify the court in light of these abstract values, but in light of as applied to. That's the logic, it seems to me, just looking at it, you know, from the outside.
Robert, we have one more question, and this has come from one of our alumni, Ray Halfston, alumnus from 1967. He says, NIFLA characterizes itself as a card-carrying member of the pro-life religious council. Should or ought their admission make a difference?
Right. I mean, this is like the question, I'm a doctor and I'm a card-carrying evangelicist and I believe in God. Does that mean because I believe in God, I can give you religiously sanctioned treatments that are incompetent? And the answer typically is no. If you're holding yourself out to practice medicine, you're subject to the requirements of being a doctor. Now, this is a little more ambiguous because you're holding yourself out to give health services. So because you're a card-carrying evangelicist, does that mean that the services you give can be fraudulent or misleading, whatever? No, but then this comes back to the anterior. So how are we going to characterize the services that you're providing? Are you providing health services or are you providing moral suasion and advice? How do you answer that question? The court imagines them as providing moral suasion and advice. Its whole opinion rests on that anterior act of social characterization. That's what has to be defended if this decision is to be defended. And that doesn't turn on their being card-carrying members. That turns on the characterization of the social practice that's being engaged in. Because if they held out a shingle saying, you know, NIFLA MD, we wouldn't accept that characterization.
I really can't imagine a more appropriate, a more lively, a more engaging keynoter for this particular symposium. And it's past due time that the Maurer School of Law got Robert Post here to give one of our endowed lectures. So Professor Post, thank you on behalf of the faculty, on behalf of all the symposium participants and our attendees near and far. Just a couple of brief announcements. Thank you. For those of you who need the CLE code, it was posted in chat, but it is 03221. 03221 is the CLE code. We will reconvene at 1:30 for the second of the remaining two panels. Once again, if you want to see the agenda for the program, it's law.indiana.edu/compelled-speech. With that, I think we will give you some time to get yourself together and have some lunch, take a brief break, and hope to see you back at 1:30.